5 seconds. A three-judge bench of this court in Larsen and Toubro Limited and another versus State of Karnataka and another reported in 1 SCC 708 was faced with the question whether taxing the sale of goods in an agreement for the sale of a flat by a developer or promoter was permissible. This court, when dealing with the said issue, made some pertinent observations with regard to 1. The interpretation of Article 366 of the Constitution, 2. The scope and meaning of works contract, and 3. The application of the dominant intention test. They read as it is important to ascertain the meaning of subclause B of clause of Article 366 of the Constitution, as the very title of Article 366 shows. It is the definition clause. It starts by saying that in the Constitution, unless the context otherwise requires, the expressions defined in that article shall have the meanings respectively assigned to them in the article. The definition of expression tax on sale or purchase of the goods is contained in clause. If the first part of clause is read with subclause B along with later part of this clause, it reads like this: tax on the sale or purchase of the goods includes a tax on the transfer of property in goods involved in the execution of a works contract, and such transfer, delivery, or supply of any goods shall be deemed to be a sale of those goods by the person making the transfer, delivery, or supply, and a purchase of those goods by the person to whom such transfer, delivery, or supply is made. The definition of goods in clause 12 is inclusive. It includes all materials, commodities, and articles. The expression goods has a broader meaning than merchandise. Chattels or movables are goods within the meaning of clause 12. Subclause B refers to transfer of property in goods involved in the execution of a works contract. The expression in some other form in the bracket is of utmost significance, as by that expression the ordinary understanding of the term goods has been enlarged by bringing within its fold goods in a form other than goods. Goods in some other form would thus mean goods which have ceased to be chattels or movables or merchandise and become attached or embedded to earth. In other words, goods which have by incorporation become part of a movable property are deemed as goods. The definition of tax on the sale or purchase of goods includes a tax on the transfer of property in the goods as goods or which have lost its form as goods and have acquired some other form involved in the execution of a works contract. Viewed thus, a transfer of property in goods under clause B of Article 366 is deemed to be a sale of the goods involved in the execution of a works contract by the person making the transfer and the purchase of those goods by the person to whom such transfer is made. The states have now been conferred with the power to tax indivisible contracts of works. The taxable event is a deemed sale. It is open to the states to divide the works contract into two separate contracts by legal fiction. One, contract for sale of goods involved in the works contract, and two, for supply of labor and service. By the 46th Amendment, the states have been empowered to bifurcate the contract and to levy sales tax on the value of the material in the execution of the works contract, whether the contract involved a dominant intention to transfer the property in goods, in our view, is not at all material. It is not necessary to ascertain what is the dominant intention of the contract, even if the dominant intention of the contract is not to transfer the property in goods, and rather it is the rendering of service, or the ultimate transaction is transfer of immovable property, then also it is open to the states to levy sales tax on the materials used in such contract if it otherwise has elements of works contract. The view taken by a two-judge bench of this court in Rainbow Color Lab that the division of the contract after the 46th Amendment can be made only if the works contract involved a dominant intention to transfer the property in goods, and not in contracts where the transfer of property takes place as an incident of contract of service is no longer good law. Rainbow Color Lab has been expressly overruled by a three-judge bench in Associated Cement. There is no doubt that to attract Article 366, there has to be a works contract. But then, what is its meaning? The term works contract needs to be understood in a manner that Parliament had in its view at the time of the 46th Amendment, and which is more appropriate to Article 366b. Students, be ready for the outlines. 5 seconds to go. Larsen and Toubro, promoter, pertinent, intention, definition, broader, embedded, execution, fiction, sales tax, rainbow, developer, permissible, observations, interpretation, in some other, merchandise, immovable, indivisible, bifurcate, dominant, color.